Good morning. Uh, the most important information may help you if you want to go ahead a step in the society by floating a company or being a standing counsel for a construction company, contractual company with the government, whatnot. So it will definitely rather help you apart from understanding the certain provisions of Contract Act, particularly section 65, 70, 72 of the Contract Act, and also arbitration and conciliation proceedings, how that works out, the dispute between the parties. This is a judgment AR 2025 Calcutta 103. AR 2025 Calcutta 103. Kolkata Metropolitan Development Authority versus South City Projects, Kolkata and another. Actually, this Kolkata Metropolitan Development Authority called for a tender to develop sites, two pieces of lands. See, the South City Project, Calcutta, had entered into consortium with, that means jointly entering into an agreement to claim tender. That is what here had happened. Actually, there was some problems by which, and after he became a successful tender, this consortium between two companies were declared selected bidder. So thereafter there was a first memo of understanding with Kolkata Metropolitan Development Authority, but as per agreement and other terms, which you may go through the judgment. This is the AR 2025 Kolkata 103, Kolkata Metropolitan Development Authority, South City Projects, Kolkata and another. But thereafter, due to non-availability of certain possession of land, another memo of understanding was executed, wherein lands were reduced. Instead of this area of lands. That was initially it was 1.32 quotas and 1.487 acres, but later on that was reduced, and still there was some financial dispute between these private companies and the development authority. They approached arbitration. So the arbitration, when appointed, the authority did not raise any objection for the jurisdiction, but later they raised an objection stating that the claim on behalf of first memo of understanding is not maintainable because of novation of contract. Novation of contract means when there was a contract first initial, and by agreement between the parties, the new parties may be added, new terms may be added, or at least totally new contract may be executed. So if that is called novation of contract, but here the Calcutta High Court held there was no novation of contract, because second memo of understanding totally accepts all the terms and conditions of first memo of understanding. This way they are developed. So these things you should understand if you want to know all these things, and kindly go through the entirety of judgment. So the Indian Contract Act 65, 70 and 72 are applicable in this given case. This is what judges says as axiomatic. These things are there, and so many other words were quotas of land. Quotas means measurement at where the Calcutta being prevailed. Then at paragraph 24, multi-number of Supreme Court judgments were discussed about consortium, contract, and arbitrators' competency. All these things are discussed. Kindly go through this judgment. I hope you understand how, well, if you do not have sufficient money but you are having a company and you can join with other company for bidding, that is called consortium. And so many things are there in field of business and entering into contract with department and other things, in participating in tender. So many things are there. Kindly step by step try to understand this area of subject, so that if somebody approaches suddenly, you can help them. You can recollect by reading all these. Best wishes.